We have a relatively full afternoon yet to go. It's my pleasure at this time to introduce our next panelists on the program. To my far left, Ms. Andrea Walker, who is from the Ministry of Community and Social Services, more commonly known as ComSoc. She is a University of Victoria graduate, a representative from Lotus Land. She attended Osgoode Hall Law School and was admitted to the bar in March of 1972 in Ontario. As I indicated, she's with the Ministry of Community and Social Services in the Legal Services branch and is a solicitor in the legal sense of the word with that ministry. To my immediate left is Allan Q. Shipley, who in addition to many other things, was counsel on the Task Force of Vandalism, which I had the pleasure of sharing. And I must say again publicly that much of the credit that report is now beginning to receive federally and provincially is largely due in part to counsel's work. Allan is a BA graduate from the University of McGill with honors in philosophy and political science. And he had kept this from me before, but I now understand he also has a Master of Science degree in economics from the School of Oriental and African Studies, University of London. South Asian politics. His degree of law from Osgoode Hall Law School and called to the bar in 1976 has been with the Ministry of the Attorney General since 1976, working primarily in the area of policy and law relating to children. I turn the matters over to you now, Allan, and you can explain some of your duties this afternoon.
Thank you very much, Chairman, Your Honor. It was also a great pleasure for me to work as counsel, too. Judge Beaulieu on the Task Force on Vandalism. Although your program notes may say that this part of the program is about alternative measures, for the most part, it isn't. Some of the earlier material that was distributed advertising the program also said also that it was about related legislation, related provincial legislation implementing the Young Offenders Act. And that's primarily what I'm going to talk about and that Andrea is going to talk about as well, the provincial legislation implementing the Young Offenders Act. Okay, what's our time on this? When are we supposed to be finished? 20 All right. So what I have to say about alternative measures, I can really say quite briefly, because as of this date, there are no alternative measures programs in effect in Ontario. So that could dispose of the matter there. That's not to say that there will not be. But if you look at Section 4 of the Act, it states that, you don't need to look at it right now, it states that alternative measures shall be used only if they are part of a program authorized by the Attorney General. And no programs have yet been authorized. In the past, the diversion programs that were running under the Juvenile Delinquents Act were for the most part sponsored by, funded by the Ministry of Community and Social Services. They have reviewed their programs that they had operating under the Juvenile Delinquents Act and have recommended that a number of those be authorized by the Attorney General's Department, and we are at the stage of reviewing those recommendations. So it is uncertain just which ones, if any, will be authorized. But just to give you a little bit of background and say something about alternative measures, you should know that there are a number of general issues that have to be addressed and that will probably be around even after we've made whatever decision we're going to make. And that is that the Charter of Rights does, the Equality Rights provision, Section 15, which is going to come in next year, may have an effect on alternative measures programs. We just don't know what it is. If we have equality rights, does that mean that if one province has alternative measures, all provinces have to? Or within a province, can we have them in one part of the province and not in the other part? Can we have them for 12 to 15-year-olds but not 16 to 17-year-olds? There are many, many questions that are unanswered about the effect of the Charter on alternative measures, and I'm not sure that the federal government addressed their minds to those various questions. So there will always be a Charter issue, I think, with respect to alternative measures. The other question is whether or not the federal legislation setting up the alternative measures authorization is in fact constitutional itself. There was a reference to the British Columbia Court of Appeal on the constitutionality of many aspects of the Young Offenders Act, and alternative measures was one of the items identified. The question being, if you're talking about a program that is an alternative to criminal proceedings, does the federal government have the legislative authority as under its criminal law and procedure power to legislate with respect to alternative measures? Unfortunately, that British Columbia Court of Appeal reference was withdrawn for a number of reasons, and it didn't proceed, so we don't have an answer on that issue either. Those are the general overriding issues. The specific issues that I've identified, or some of the specific issues on alternative measures, are the very first issue, and that is, what is an alternative measure? There seems to be a definition in Section 2, and you always should look at that when you're, although Section 4 is the main section on the substance of it. But Section 2 says alternative measures are measures other than a judicial, what's a judicial proceeding, as opposed to a legal proceeding or a court proceeding or whatever. We don't and won't for some time have any jurisprudence on that. But you have to think every time about that definition. Measures other than a judicial proceeding. The other things to note about alternative measures are, of course, that they apply, or Section 4 of the Young Offenders Act applies only to federal offenses. We're not talking about provincial offenses or anything of that nature. Then when you get into the substantive criteria set out in Section 4 that are the elements of an alternative measures program, you have clauses A to G, which say that an alternative measures program may be used only if A, B, C, and so on. And all I can say, without spending a lot of time going through every clause, all I would caution you is to look at every word in there and look at every phrase and think about what it means. The provision, in my view anyway, is not carefully drafted at all. Concepts that are included here are differently expressed elsewhere in the Act. There's just a lack of legal precision in many of the phrases and clauses. If you look at Clause E, for example, the young person, in order to qualify for alternative measures, must accept responsibility for the act that forms the basis of the offense. Well, that's obviously something different from being prepared to plead guilty to the offense. It's phrased differently. It obviously means something different, but what it means, we don't know. So that's the kind of a thing you should be thinking about if you're dealing with an alternative measures program. Also note that the Crown Attorney must now be involved in every alternative measures program. That they may have been involved sort of in approving in general the program, but they weren't involved in a case-by-case, on a case-by-case basis in the current programs. The other thing is that although alternative measures may be used only if A, B, to G, the Young Offenders Act itself doesn't spell out the consequences of failing to comply with those conditions. We don't know what would happen if the program didn't comply. I'm not saying there are no consequences, it's just not clear what they are. And I think the other thing I would caution you about is Section 4, subsection 3, which says that only those admissions made by a young person as a condition of alternative measures are inadmissible in other proceedings. So that doesn't mean all statements made by the young person in the course of being in the alternative measures program or part of the investigation before being in the alternative measures program are inadmissible. It's only those admissions that are a condition of alternative measures that are inadmissible. So that I'm sure that is going to be a very important point as alternative measures break down or whatever, and they want to continue prosecuting the young person, and those statements that he's made will be very important. The final thing I just wanted to point out to you on alternative measures is that the concept itself is far from proven. It is heavily promoted, in my view, by the Federal Solicitor General's Department, but it is really an untested concept. I was going to take a couple of minutes to read to you from a research paper prepared for the Federal Solicitor General's Department and published in 1982, just when the Act was coming into effect. It deals with pretrial diversion in general, adults and young persons. And of course, although the Federal Solicitor General's Department published it, they did so with the usual disclaimers that the paper doesn't represent the views of the ministry or whatever. But I think there are some things in here that we should consider and keep in mind when we're thinking about alternative measures. And in one of the paragraphs, the researcher reported to the Federal Solicitor General's Department, the research evidence on the benefits to society, to the diverted defendant, and to the criminal justice system has been negative or ambiguous and conflicting. Claims by advocates that diversion could reduce recidivism, reduce court workloads and costs have largely been rejected by researchers. Critics concerned with individual rights have stated that those rights have been denied by the process of diversion. Furthermore, target populations have tended to be the defendants who present little risk to the community and who would have received a non-institutional disposition from the courts. Both civil libertarians and researchers have asserted that the goal of minimization of penetration into the criminal justice system has not been reached. On the contrary, they state that the net of the system has been widened. The concern is that the people who get dealt with in alternative measures programs, in diversion programs, are the kids, or the adults, the kids who never would have been charged in the first place in a normal police discretion system. What happens is once you set up a program, it attracts clients who never would have been in the system otherwise. So it's a widening of the net, bringing more people into the system than would otherwise have been there. That ends my little presentation on alternative measures. What I really wanted to talk to you about is provincial offenses, because we do have provincial offenses, and we do have provincial offense legislation. As you may know by now, the Young Offenders Act does not apply to provincial offenses. In 1979, Ontario enacted the Provincial Offences Act, with one of its main purposes being to establish a procedure that reflects the distinction between provincial offenses and criminal offenses. That belief in different procedures for a provincial offense and a criminal offense is now applied to young persons as well. So, what that means is if you're dealing with a young person who's charged with a provincial offense, you're not thinking about the Young Offenders Act or the Criminal Code at all. You're in a whole different stream, and that is people who are charged with liquor offenses, highway traffic offenses, petty trespass. You're under the Provincial Offences Act, and that is your code of procedure. The starting point is the Provincial Offences Act that applies to adults for the most part. If you're not familiar with the Provincial Offences Act, because most provincial offenses are dealt with on a ticket basis, but if you're not familiar with the procedural parts and the trial provisions, then I'd recommend to you a book called Ontario Provincial Offences Procedure by Doug Drinkwalter and Doug Ewart. I'm not flogging this just because Ewart is my boss. And it really is an invaluable aid to understanding what provincial offenses are all about. So what we have basically is the Adult Provincial Offenses Act with 17 sections added in a special part to modify the adult provisions for young persons. The major modifications, the major changes we've made are that the provisions apply to persons 12 to 15 inclusive, that's your current YOA age. Probably the most major provision is that the ticket procedure, the pay out of court, the offense notice procedure is not available for a young person. Any young person charged with a provincial offense must appear in court. The two other major modifications, one is that the Provincial Offences Court, where the defendant is a young person, will be presided over by a family court judge rather than a provincial offenses JP. So it's still in the same court where he always was, where he is with under the Young Offenders Act, but it's sitting as a provincial offenses court with all the rules, all the forms, all the procedure applying, all the provincial offenses procedure. And the other thing, of course, is that the sentences have been modified. How am I doing for time? Another 3 or 4 minutes? I've got another 10 minutes, but anyway.
Sorry.
Andrea says that she won't take up all her 15 minutes. Basically, for provincial offenses, there are two methods of proceeding. One is the Part 1 summons, which is usually issued by the officer at the scene. It's just like the ticket that he writes out for an adult, but instead of giving the ticket, he uses the same stuff, but what he'll write out is the summons part of the ticket and give that to the young person. Proceedings can also be taken by way of information under Part 3 of the Provincial Offences Act. The difference is if you go under Part 1, you get one set of penalties. If you go under Part 3, you get a different set of penalties. That's the difference in the kind of proceeding. A copy of this summons, a copy, has to be delivered to the parent. We have a form like that, copy of summons. The delivery can be personally or by mail, and unlike the Young Offenders Act, the summons does not affect jurisdiction. It's primarily a courtesy kind of notice to let the parents know that the child is involved with the justice system. There are no special provisions for compelling parents to attend, as there is in Young Offenders Act. If it's really necessary to get the young offender there, or the parent there, a subpoena could probably be issued under the Section 40 of the POA. POA is the jargon for Provincial Offences Act. Arrest powers for adults, of course, are very circumscribed for provincial offenses. You know that you can't be arrested for most of them. The same applies for young persons, except they're even further modified so that he can be arrested only if there are reasonable probable grounds to believe it's necessary in the public interest to establish our identity or to prevent the commission of a dangerous offense. It's a case, of course, with young offenders as it is with adults in provincial offenses cases, that if they persist in committing the provincial offense, even though there's no arrest power for it, if they persist in committing it, then they could be charged with obstructing justice under the code and brought in under the YOA. There are bail provisions, essentially the same as adult bail provisions under POA, which are different from criminal code and YOA. And as I said, the young person must attend that trial. There are no ex parte convictions as there are for adults. One of the things that you should always keep in mind if you're dealing with a provincial offense, whether it's a young person or an adult, is that for most of provincial offenses, not all, but for most, there's no need for the prosecution to prove mens rea. And it's a different standard of proof. And if you want to go into the background of that, I'd suggest you look at Regina against Sault Ste. Marie. It's a Supreme Court of Canada decision in 1978. It is discussed in Drinkwalter and Ewart and other places. But it's a very significant decision on mens rea and provincial offenses. The sentencing provisions, as I said, if you use a Part 1 summons, you get one level of penalty. If you use a Part 3 information, you're subject to a different level of penalty. Part 1 summons. The penalties are set out in Section 91E of the amendments. There's an absolute discharge power, which is new. There is a power to levy a fine. Now here, in order to maintain some equality between the young person charged with a provincial offense and the adult charged with a provincial offense who gets to send in his $28 to court and never having to appear, we've said that the fine for a young person, if he's fined, can't be more than the set fine, the amount of the fine that an adult would pay on a out-of-court ticket. And it doesn't even have to be that much, it could be less. But if it's a speeding or trespass and the fine is $50, the young person would never have to pay more. If there is no set fine, then the maximum is $300. There is a special provision for young persons if a Part 1 summons is used to make a probation order with a very short term of 90 days. If the police proceed by way of a Part 3 information, a more formal kind of proceeding, the sentencing powers again are absolute discharges, a fine, but this time the maximum is $1,000, the same as in young offenders, and probation maximum of 1 year. You should look at Section 72 of the Provincial Offences Act, the main act, to see what the conditions of probation are. I won't go through all of those, but they'll be quite important. And of course, if the specific act under which the offense is committed, the Highway Traffic Act or the Game and Fish Act or whatever, provides other kinds of penalties such as forfeiture of your fishing rod or something like that, or suspension of a license, then those penalties apply as well. One of the other interesting features of our amendments on provincial offenses is that a young person cannot be imprisoned for a provincial offense in the first instance. But at trial, the sentence can't be, there is no power of imprisonment. There is one very small matter that I'll deal with in 2 seconds that I have left. If the kid can't go to prison, so how are you going to enforce any kind of penalty? The enforcement powers are important. The main enforcement powers of Provincial Offences Act apply. There's a power of civil enforcement. You can register the fine with the Small Claims Court and that sort of thing. License suspension powers, which are also important, because even though we're dealing with kids under 15 who don't have licenses, there are provisions under the Highway Traffic Act preventing the person from getting a license if he has outstanding fines. So that'll be an important consideration for kids. If the fine is unpaid and an adult would be sent to jail because he had failed to pay, and this is dealt with, I can't remember the sections in the Provincial Offences Act, but if this kid is in a situation where he would be jailed for failure to pay a fine, then the young person is put on probation instead. Now, the crunch comes, what happens if he breaches probation? That is the only instance under the scheme in which we have reserved the power to sentence the young person to custody. If there is a breach of probation, and it's dealt with in Section 75 of the Act, then one of the options available to the court is to sentence the young person to custody for a maximum of 30 days, and that would be served in the same custodial facility that's used for young offenders. Just one final point. When the young offenders' age rises in 1985 to include the 16s and 17s, we haven't made a final decision on what we will do with 16 and 17-year-old provincial offenders, but I think at this time we don't intend to bring them into the amendments that I've talked about, because most of the offenses are driving offenses. But if we don't bring them in, then there will have to be some further adjustments to deal with that situation of the 16 and 17-year-old who commits a provincial offense and is dealt with as an adult, and if he commits a criminal offense, he's dealt with under the Young Offenders Act. So there'll have to be some adjustment there. That ends my little presentation. Thank you. Andrea, did I leave you any time?
Yes, thanks. Your Honor, Allan. The Ministry of Community and Social Services has been assigned the responsibility for implementing programs under the Young Offenders Act in Ontario for young persons who are 12 years of age or over, but under 16 years of age. The ministry has taken 3 steps to implement the federal act. The first being the enactment of orders in council, the second being the introduction of Bill 28, being an act to implement the Young Offenders Act in Ontario, and the third being the introduction of Bill 77, which is the Child and Family Services Act and provides for a major reenactment of all the legislation and policies relating to the provision of services for children in the province. 3 orders in council were passed, effective April 2nd, 1984. The first was an order in council delegating to the Minister of Community and Social Services the authority vested in the Lieutenant Governor in Council or his delegate under the Federal Act, i.e. the YOA, to designate places of temporary detention for the purposes of subsection 7.1 of the YOA, and to designate places as places of open custody for the purposes of subsection 24.1 of the YOA. The order in council was numbered 890 for 84. The second order in council delegated to the Minister of Community and Social Services the authority to appoint persons as provincial directors and as probation officers. Probation officers may be appointed to perform any of the duties and functions of a youth worker for the purposes of the YOA. And that order in council is numbered 891 for 84. The third order in council passed was an order in council to designate places of secure custody for the purposes of the Young Offenders Act. And this is one of the matters in the Federal Act that cannot be delegated, either to delegated at the provincial level to a minister or delegated in a provincial act. So that places of secure custody, whether they're going to be added to the list, subtracted to the list, or changed, must always be dealt with by way of an order in council or an amendment to the original order in council. And that order in council was numbered 889 for 84. Those orders in council were effective the 2nd of April, 1984. The second measure taken by the ministry was to introduce Bill 28, to be known as the Young Offenders Implementation Act, 1984. Provisions in this bill are required to implement the Federal Act in a number of ways. And I'd just like to go very briefly through the major provisions of the Act with you. Before I do, I should point out that this bill is still before the House at the second reading stage. And we hope that it will be proceeded to a conclusion fairly shortly. The first section that you should note, and I know there were discussions about services and programs earlier today, is Section 3, which authorizes the Minister of Community and Social Services to establish, operate, and maintain and purchase services and programs for the purposes of the Young Offenders legislation. Services and programs are defined in the legislation to mean such programs as pretrial detention and supervision programs, open and secure custody programs, probation services, programs for the administration and supervision of dispositions. This authority was required in order to permit us to establish, fund, and operate the complementary programs to implement YOA. The second section to which I'd like to draw your attention is Section 6, and that relates to a matter Allan discussed with you a moment ago. Section 6 is complementary to the Provincial Offences Act and provides that where a young person is sentenced to imprisonment for a breach of probation under Clause 75D of the POA to be served in open custody, the young person is to be held in a place of open custody specified by a provincial director. And in addition, the section also makes applicable the provisions of Section 35 of the YOA with respect to temporary release. This is to ensure that young persons who come in through that system are treated equally with those who come in through the YOA directly. Another important section to note is the section dealing with the ministry's powers with respect to temporary care and control, i.e. the powers of apprehension of young persons who are AWOL from places of temporary detention and places of custody. This authority is contained in Section 7 of the bill. The provisions are similar to those contained currently in the sections of the Provincial Courts Act administered by the Ministry of Community and Social Services. But the one thing that you should note if you're working with the bill when it comes into force is that the authority with respect to CAS AWOLs has been included in the section of the bill by way of amendment to the Child Welfare Act. The third major provision in the bill is the authority for police to apprehend children who are under the age of 12 years. And this will be done by way of amendment to the Child Welfare Act and become sections 21 sub 3 to sub 3B of that act. This section provides that where a police officer who has reasonable and probable grounds to believe that a child actually apparently under the age of 12 years has committed an act in respect of which a person 12 years of age or older could be found guilty of an offense, the police officer may apprehend the child without a warrant, and in doing so may, as soon as is practicable, return the child to the child's parent or other person having charge of the child, or where it is not possible to return the child to the parent or other person within a reasonable time, take the child to a place of safety, to be detained there until the child can be returned to the parent or other person. Once the child is in the place of safety, the onus shifts to the person in charge of the place of safety to make reasonable efforts to notify the child's parent. And where the child's parent cannot be notified within 12 hours, and the child is held 12 hours in a place of safety, the child is deemed to be apparently in need of protection and thereby plugged in to the child welfare system. You should also note that the bill contains transitional provisions with respect to children who are, quote, in the system at the time the Young Offenders Act came into force, including provisions dealing with children who are wards of training schools. And the transitional provisions are complementary to those contained in the federal legislation. The third initiative taken by the ministry has been to introduce Bill 77, the Child and Family Services Act. This bill was introduced last Friday and contains a number of parts that may be relevant to the Young Offenders Act when it comes into force. It is our understanding that printed copies of the bill should be available shortly. We were told it would take a week for them to be available. It is a very substantial bill in terms of content as well as bulk, and I would commend your attention to it because it contains reenactment of the Child Welfare Act, the Young Offenders provisions, the Children's Probation Act, the Provincial Courts Act, and so forth as part of this overall reform of provincial policy concerning services for children. And I'd like to draw your attention particularly to three parts of the bill. The first being Part 4, which deals with young offenders. And this part, in addition to being complementary to the implementation bill, contains criteria for the admission of young persons to secure levels of custody and detention. As far as custody is concerned, as you know, there are provisions, criteria set out in the YOA for admission of a child to secure custody, and we have divided the levels provincially and set criteria for admission to a very secure level of custody. It also contains criteria for admission of children to the most secure level of detention. At the present time, we have 3 levels of detention generally in the province, and the most secure level will be subject to fairly rigid admission criteria. Part 3, the reenactment of the child protection section, is another particularly important section, and I draw your attention to the revised definition of child in need of protection, which will deal with some of those children under 12, as I believe Judge Thomson mentioned earlier this morning. Thank you.
Thank you very much. There may be time for one or two quick questions. If not, I want to thank you again, Allan and Andrea. Now I'd like to call on Gregory Johnstone and Dr. Jaffe to come up, please. To move on to the next segment of the program, which has to do with medical, psychological, and predisposition reports. To deal with those topics, we have the benefit of the presence of, to my far left, Gregory Johnstone. And I might say that Gregory called me yesterday to plead with me to say that he might not be available. He was on a sick bed and et cetera, et cetera. I told him to get rid of whoever it was and make sure he got here. But we are very fortunate indeed to have him with us, because Greg is a man who is not only well versed in the law, but has also participated in many seminars and lectures. He's a graduate of the University of Toronto, Boswood Hall Law School. He articled for MacDonald and Ferrier in family law for half of his period of articles, and then articled with J. Arthur Martin QC in criminal law for the rest of that period. He was called to the bar in 1970. He is presently involved in private practice and does work that is primarily limited to matrimonial and criminal law. He is an active and very active member of the Bar Association, both in the national and local level, in the family law section, subsection, and the criminal law subsection. He is on the Legal Aid Area Committee in York County and has been since 1980. He is, as I've mentioned, a lecturer and a group instructor with the Bar Admission course, with the Continuing Education, the Law Society. He has been involved in the Federation of Law Societies for Canada as a program coordinator and instructor across this country. The list goes on and on. He's also involved in numerous community activities. He says that he's married and has 4 children. I don't know whether he has time to see them, but in any event, we are indeed pleased to have him here with us today. To my immediate left, we have Dr. Peter Jaffe, who is the Executive Director of the London Family Court Clinic. Here again, these two curriculum vitae are something like 2 calendars. Dr. Jaffe is not only the director of the clinic in London, he is also the coordinator of the London Custody and Access Project. He's assistant professor of clinical psychology at the university. He's a director of the Family Consultant Service with the London Police Force. He's a psychometrist. He's a registered psychologist for the province of Ontario. He's an adjunct, you got to watch how you pronounce some of these words, adjunct professor, Department of Psychology, assistant professor, Department of Psychiatry in London. Community involvement involves the Board of Education, the Committee for Children and Youth, the Justice Committee, Child Abuse Council, Management Committee, Family Consultant, research contracts, criminal justice system with respect to wife abuse, family crisis intervention for the Solicitor General of Canada. There are dozens of these things. The impact of exposure to marital violence on children, the Ontario Mental Health Foundation. And then we get into about 4 pages of addresses, publications in scientific journals. It goes on, as I say, and we could be here for another 5 minutes on that alone, but needless to say, I wanted to mention at least this much to indicate to you the caliber of the individuals that we have to deal with these particular subjects, and indeed how appreciative we are to have you present. Greg, I'll turn it over to you at this stage.
Thank you, Your Honor. I thought you were supposed to read it all because we really don't have a great deal to say, at least I don't. I'm going to do what I presume has been done for other parts of the day, and that is try and go through this legislation sort of piece by each for about 10 or 15 minutes, and Dr. Jaffe is then going to take over and do the interesting and informative part of the presentation. So if you'll bear with me, our starting point, I guess, is section 13, which I know you've all turned to right now. There's a quick and complete summary, and this is in relation to medical and psychological reports, in the Ferns and Pearson material from pages 56 through 62. There's a longer discussion with an attempt to, in my opinion, to justify or rationalize the interference with the privacy of the young person in the Blue Book, running from page 98 to page 120. I'm going to try and approach this at a very elementary basis, only because that's the only way I can perhaps come to grips with some of these problems myself. Obviously, I think the person who is subject to the medical or psychological examination is the young person, not his family, although his family may play part of it, not his school, but the focus of the report of the examination is the young person. The order it results from an order made by the youth court, and if you take a look at 13.1a, actually 13.1, and at the tail end of C, a youth court may at any stage of the proceedings, so that there's no mysterious time to do it. It appears that it can be done after a finding of guilt, but before disposition. It appears that it can be done prior to the commencement of the hearing. Prior to the commencement, it would appear, of an application for transfer. Now, what triggers the making of the order as I read this, and this is a cursory glance, I've only, like many of you, had an opportunity to go over this legislation 2 or 3 times, and a lot of these are quick opinions. They have not been firmly decided one way or the other. But it appears, according to section 13.1d, that the judge can make an order for an assessment, in effect, with the consent of the young person and the prosecutor. And if one reads that part the way I read it, it would appear that from that wording, the order would go automatically. It would go on consent. The criteria set out further in the next part may not have to be applied. It may be sort of the equivalent to a waiver of a preliminary inquiry set up in the adult criminal process. If both parties consent to the report, we'll get on with having the report of the assessment done. The more usual circumstance, presumably, will be an order made under section 13.1e. And that is a section which, in my opinion, merits very close and careful reading and consideration. First of all, as you can see from reading it, the youth court may, on its own motion, again at any stage of the proceedings, on its own motion, or on the application of either the young person or the prosecutor, make an order. But then there are certain criteria that need to be applied in making the order. Under 13.1e, the court appears to have reasonable grounds, not reasonable and probable grounds, don't get confused with the criminal law, reasonable grounds to believe that the young person may be, not is likely, not is probably, but merely may be suffering from a physical illness or a physical disorder, a mental illness or a mental disorder, a psychological illness, but apparently not a psychological disorder, an emotional disturbance, but not an emotional illness or an emotional disorder, a learning disability, or mental retardation. Now, the doctor, I'm sure, will tell you that my distinctions are without a difference, but I draw your attention to the fact that they talk about physical or mental illness or disorder and only talk about psychological illness, emotional disturbance, and learning disability and mental retardation. And then, I'm sure if you look at this as you work your way through, you notice the test, for lack of a better term, seems to weaken. It seems to become more generalized. Once the court's decided that there's some reason to believe that the child may be, or the young person may be suffering from any one of these things, and the court believes a medical, psychological, or psychiatric report. Now, it's not the court being satisfied. It's merely the court believing, whatever that term means to the legal mind or to the judicial mind, believes a medical, psychological, or psychiatric report, and then we come to the stage, might be helpful. So we have a court that on reasonable grounds believes someone may be suffering from any one of the included items, a court that believes that such a report, if ordered, might be helpful in making, and I draw your attention to the last 5 or 6 words of 13(1)(e), to making any decision pursuant to this act. Now, that reads somewhat inconsistently with the introduction to section 13(1), that is, inconsistently with the sections 13(1)(a), b, and c, which says, and I'll read it to you, just so you'll read it with me, for the purpose of considering an application under section 16, determining whether to direct that an issue be tried whether a young person is on account of insanity unfit to stand trial, or making or reviewing a disposition under this act. Now, on first blush, it would appear that these reports can only be used for those purposes until you read the last phrase, for lack of a better term, in 13(1)(e). And then apparently it can be used if it might be helpful in making any decision pursuant to this act, which would be an issue on the adjudication or the finding of guilt, the finding of mental capacity, if an issue of specific intent were raised, automatism, a multitude of other things which you may or may not, as a defense counsel, want dealt with or choose to deal with in your own way. It would appear, if the court thinks, or if the prosecutor can convince the court that it might be helpful in making or dealing with that part of the process, then a report can be ordered. So I caution you to come prepared to take, to deal with this problem, because it's going to come. There's no doubt that the background information and material gathered may be much more valuable from the Crown's point of view than the merely limited purpose for which the section appeared to be designed when one reads A, B, and C and doesn't bother reading too carefully the other parts of that provision. The examination is done by a qualified person. Dr. Jaffe, I think, will deal with the issue as to who is a qualified person. Section 1311 sets it out in general legalese. Basically, you have to be a licensed doctor, and even a licensed psychiatrist is deemed to be qualified, or someone is licensed to carry out psychological examinations. The court has the power to remand the person to be examined into custody for up to 8 days. That appears under section 13 sub 3. And that can be increased up to 30 days where the court is satisfied that a longer period of observation is required. I hate to continue to refer to these subsections and so on and so forth, but one of the pleasures I've had in doing this act is to be able to tell you, because this is sort of the level at which my mind works, that this little piece of legislation involves itself with 81 sections and 332 subsections. You don't have to count this. This is something you can take away for your own personal knowledge. 81 sections, 332 subsections, 272 subsections, and 37 subsections, and there's no other way to refer to this material or work your way through it except go piece by each. It is a very broad piece of legislation, and in my opinion, very, very complex. Because the next area that we get to is the distribution of the report. Who gets the report once it's done? The answer to that is very simple. The young person, his parents, his counsel, and the prosecutor. That appears under section 13.4. However, don't be too sure of that, because you then have to move, I think it's to section 13.6, which talks about the withholding of the reports. Section 13.6 says that when the report is done, a youth court may withhold the whole or any part of a report made in respect of a young person, pursuant to subsection 1, from the private prosecutor, where disclosure of the report or part thereof, in the opinion of the court, is not necessary for the prosecution of the case and might be prejudicial to the young person. Or, and this is the thing that should concern you as counsel, the young person, his parents, or private prosecutor, where the person who had made the report states in writing that the disclosure of the report or part thereof would be likely to be detrimental to the treatment or recovery of the young person, or, and I love this section, or would be likely to result in bodily harm to or be detrimental to the mental condition of a third party. Certainly a reasonable risk, considering some of the people you and I have dealt with in the courts, and when we get the pony leaguers as opposed to the little leaguers in there, that is, when we get up to the 17-year-olds in there, it may be of more valid concern. The issue that arises there as counsel is that there's no right for the court to withhold that report from counsel. Counsel is entitled to the report even though his client is not. The adult assisting the young person, that is not the counsel, but an adult going in to assist the young person, may not be entitled to any more of the report than the young person is entitled to. It is probable that the only way that person can get a report is by getting what is given to the young person, if anything is given to the young person. The question that arises from counsel's point of view is, given the report, given a direction of the court that the young person is not to have all or not to have some part of the report, and given your right of cross-examination of the person who prepared the report under section 13.5, what do you as counsel do with the report once you have it? If you are satisfied that there may be inaccuracies in those parts of the report that are prohibited from being given to your young offender, what do you do about it? How do you question them about it without directly or indirectly revealing what those parts of the report contain? How do you conduct a cross-examination on what may be very salient parts of the report and what may be weak parts of the report in the presence of your client in the courtroom when such is not to be revealed to him? Can he be excluded from the courtroom under the general provisions of the criminal code? Can you convince him that it would be in his best interest not to be in the courtroom and to voluntarily remove himself from the courtroom? If he does so, does that amount to a mistrial? Just a mere procedural legal issue that I leave with you. Now, that is the medical or psychological report, and I've skipped through it very quickly. It can be given orally if the circumstances dictate. We can cover a couple of other areas. Remember that this report, along with the next one that we're going to talk about very briefly now, the predisposition report, become a part of the record. Once they're filed, they're part of the record, and although it's not on the material today, if you skip ahead, I think, and look at section 40, and I'm sorry that, section 40, subsection 3E in the legislation. You have to understand my bias, of course, as one as defense counsel. and you think back to the case of Regina and Ray and the whole issue of derivative evidence and inadmissible statements, you will notice that the report, access to the report, be it the predisposition report or the medical or psychological report, can be given to any peace officer for the purpose of investigating any offense that the young person is on reasonable and probable grounds suspected of having committed. So whatever your young offender has committed himself to by way of statement, acknowledgement, agreement, during the course of the preparation of the report that's included in the report, then becomes available at least for perusal, even though it may not be admissible in evidence. And if you think of the Regina and Ray case and a multitude of other derivative evidence cases, you may understand why you might be inclined to suggest to your client that there is not a great deal of advantage to your client, depending on the nature of the offense, of participating to any significant extent in the preparation of such a report. They're then in the situation of the Sweezy case, the refusal of the accused to let the Crown psychiatrist conduct examinations. I mean, this is real criminal law now. This is not kiddie law. We're not in kiddie court anymore. We're going to be dealing with 23% of the adult offenders. You've already been told that today. This is a criminal court. You're going to have to make some of these hardball decisions as criminal defense counsel. Just to move on quickly to the predisposition reports, we're all familiar with pre-sentence reports. These appear on section 14. I would draw your attention very briefly to a quote that appears at page 127 in the blue book about pre-sentence reports. And this is repeated in a number of courts of appeal across the province, where Mr. Justice Ewaschuk says, in my opinion, reports of this nature should be strictly factual. They should not speculate, nor should they reach unwarranted or indeed any conclusions. They are meant to assist the trial judge, particularly with regard to the antecedents of the accused. Now, in other words, not too much gossip, just the facts, man, in terms of pre-sentence reports. However, I think perhaps we should take a look at just what is required to be included under section 14. And although on first reading I agree with the authors in this material that this is a nice palliative and this term of reference should be kept, I think section 14 may expand the scope considerably and create an opportunity for rumor, innuendo, and hearsay. Section 14, obviously the report is done when the court deems it advisable before making a section 20 disposition. It's prepared by the provincial director, who everyone presumes, according to the Act, has the power to designate the authority to prepare the report to a youth worker or probation worker, who is further defined in section 37 of the legislation. Certainly the statements made by the young person on the preparation of such a report are set out to be inadmissible except in relation to transfer applications, disposition hearings, or review hearings, that is, review of dispositions. And there's sort of a progress report, which is the same animal under another guise, that is used for reviews of dispositions. Take a look, if you would please, at 12A, B, and then let's go down to C. What's the predisposition report made in respect of a young person shall include the results of an interview with the young person, and where reasonably possible, the results of an interview with the parents of the young person, the results of an interview with the victim in the case, such information as is applicable to the case, including, where applicable, and here we go, the age, maturity, character, behavior, and attitude of the young person and his willingness to make amends. Any plans put forward by the young person to change his conduct or to participate in activities or undertake measures to improve himself. And then for those of you who are used to the proof of previous criminal convictions in some standard or form, take a look at section C, the history of previous findings of delinquency under the Juvenile Delinquency Act, or previous findings of guilt under this or any other act of Parliament or any regulation made thereunder, or under a provincial statute or a bylaw or ordinance of a municipality. These are to be included and put in without formal proof. The history of community or other services rendered to the young person with respect to such findings, and the response of the young person to the previous sentences or dispositions and to services rendered to him. The history of alternative measures used to deal with the young person and the response of the young person. So that I suggest to you that the terms of reference that we have come to think of in, for lack of a better term, the adult court, that the pre-sentence report should be pretty factual and should be limited merely to antecedents and general family background is very, very much broadened by the criteria set out in section 14. Now, the reports are as good as the person preparing them, in my opinion. The person preparing the report is only as good as the sources of information that he or she has. The reliability of the information that goes into the preparation of the report is something that may need to be tested. And I save this part simply to highlight the fact that both in relation to medical reports and psychological reports and in relation to predisposition reports, there is a right to cross-examine the maker of the report. Again, I should say that in relation to predisposition reports, they can be withheld from the private prosecutor. They cannot be withheld from the